Greetings. We have a little bit of technical difficulties. Just a moment here. We're going to get started. I'll leave the song on just for a second here for the later half, so we'll get one more shot of the vibra slap, and then we shall begin. Give me just a moment. Okay, greetings and welcome to Law of Evidence, Burdens of Production and Persuasion from American Jurisprudence. And as already noted here, this is one of the most important subjects here regarding law of evidence and judicial notice specifically. That being said, let's begin. So we're on to Chapter 3 of the Burden of Proof. Section A here, generally, in civil cases. We're going to start with the introduction here, Part 1, and Section 155, Burdens of Proof, Persuasion, and Production. The term burden of proof has been used to describe two related but distinct concepts: the burden of production and the burden of persuasion. And before we move any further, just to remind the audience that this is strictly to be used for the entertainment and educational purposes of this YouTube broadcast, only not to be used, misconstrued, or misused for any kind of legal, lawful, personal, professional, business, tax, financial, or otherwise, so please don't do this at home. So we have two distinct but related concepts: burden of production and burden of persuasion. To satisfy burden of production is also sometimes referred to as making out a prima facie case, and the term is sometimes used in legislation for this purpose. Thus, proof of the underlying fact is enough to survive a motion for a directed verdict. proof of the underlying fact is enough to survive a motion for a directed verdict. When the party has satisfied its burden of production is not an issue of fact for the jury. So whether a party has satisfied its burden of production, it's not an issue of fact for the jury. It is an issue of law. It arises when, after a party rests, an opposing counsel brings a motion for a directed verdict, or the like. So before we go further, let's look more into this directed verdict statement here. And there's probably no better way to get a general understanding of that than to go over to Black's Law Dictionary. And let's do that right now, because we don't want to leave any word behind or concepts. And if I'm going to interpret it, I'd rather get it right from a source like this so that there'll be no mistake or errors on my part. Okay, so let's see, directed verdict would be under verdicts. So that brings us very far down in the book here. Bear with me, this is a scanned document. It takes forever to get to certain sections, but once it settles in, it's easier to zero in on the word. In the meantime, I encourage everyone to please hit the like to ensure that we're getting the message out there. I know notifications have been thin lately. I didn't get one on this one, but it seems Bill Thomas did, so that's good to know. All right, we're getting there. Okay, there we go. Now it's moving. We're on the T's. We need to get to V. It'll be a type of verdict. I would just gamble at to start with, because of the way you see here, all the modified definitions of the word underneath it. All right. Almost there. Jeez. Let's see if we can jump a little faster. There we go. Ah, geez. I just saw it. Pocket veto. Here's a good one. Vestigial words. Statutory words and phrases that, through a succession of amendments, have been made useless or meaningless. Courts do not allow vestigial words to defeat the fair meaning of a statute. Good to know. Almost there. Here we go. Verdicts. We're in the verdicts here. So we want directed verdict. Let's see here. General verdict, gambling verdict, directed verdict. Here we go. Okay, let me make sure this is on the screen. Indeed. 1912. So this is current somewhat. A ruling by a trial judge taking a case from the jury because the evidence will permit only one reasonable verdict. Also termed instructed verdict. Wow. So there you go. It's a ruling by a trial judge taking a case from the jury because the evidence will permit only one reasonable verdict. Wow, that's a good one to know. Here's another one. So there's a lot of good verdicts here to learn, and this might be another study in and of itself. But now at least we have a good substantial definition of directed verdict. Defective one looks pretty good too. One that a verdict on which a judgment cannot be based because of irregularities or legal inadequacies. But what we're looking at is a directed verdict where the trial judge takes the case from the jury because the evidence will permit only one reasonable verdict. All right. We're done with that diversion. Let's get back to the book. Oops. Okay. So, when a party has satisfied its burden of production, whether a party has satisfied its burden of production is not an issue of fact for the jury. It is an issue of law. So there's only one reasonable verdict, right? It arises when, after a party rests, an opposing counsel brings a motion for a directed verdict or the like. So this is after all of the deliberations, huh? The burden of persuasion aspect of the burden of proof describes the obligation of a party to introduce evidence that persuades the fact finder to a requisite degree of belief that a particular proposition of fact is true. So the burden of persuasion is the aspect of the burden of proof describing the obligation of the party to introduce the evidence persuades the fact finder. That's your jury or judge in a bench trial, right? To a requisite degree of belief. What degree is required for their belief, for these fact finders' belief, that a particular proposition of fact is indeed true? The burden of persuasion has two components. So now we have, again, see how this starts to divide things up. Burden of proof has two concepts, production and persuasion. So proof has production and persuasion. The burden of persuasion, right, has two components also. The first, the facts a party must plead and prove in order to prevail on a particular issue. And second, how persuasively it must prove those facts. Wow. So the burden of persuasion, right? It's about the obligation of a party to introduce the evidence and the persuasion of the fact finder to a degree of belief. So the burden of persuasion has those two components. First, of facts. A party must plead and prove. So you have to have the facts to prevail on a particular issue. So they're saying these facts would allow me to prevail on this particular issue. And second, how persuasively it must prove those facts, that degree of belief. So we see those two components. They mention them here, and now here they're explicitly describing there are two components. So burden of proof has two components, and a persuasion concept here has two aspects to it too. So we have those two components there of the obligation to present the evidence, the facts, and how persuasive or the degree of belief to the fact finder it is. We're on to section 155, the burdens of proof, persuasion, and production supplement. So here's some case authorities. The assignment of the burden of proof is a rule of substantive law. Rules have evolved concerning burden of production. Rules that have evolved concerning burden of production serve many important functions, including ascertaining truth and justice. And that's from 1993. Now these are the supplements here. These are, I think this is a 1998 edition we're reading from. Again, things like law of evidence shouldn't be changing any significant way over time, considering the common law roots of this. That being said, we can't discount the changes that so-called liberal judges have been making over the years, kind of perverting our common law tradition. But I digress. Let's continue down. Let's see here, trustees. So these are just some good case authorities to use. Instructions to jury definition of burden of proof in our forms, in the pleading and practice forms, evidence forms. We've gone over some of these editions of AmJur here on this channel. So if you look in the AmJur playlist, you'll find some of those of the practice of pleading forms. Okay, instruction to jury, prima facie evidence defined. Again, another good one. All right, for instance, 15 U.S.C. 1127 provides that a trademark is deemed abandoned when its use is discontinued without intent to resume its use, and that proof of non-use for 2 years constitutes prima facie evidence of abandonment. Wow! Didn't know that one. So under U.S. Code, 2 years of non-use without intent to resume is prima facie evidence of abandonment. Interesting. For a discussion of the burden of proof requirements of a motion for a directed verdict, see section 164. We should be over that one. That should be interesting. Burden of proof and presumptions in Massachusetts. And for discussion of these two components, we'll see section 157, which we'll be at shortly. All right, let's jump over to the chat before we go to the next section. All right, vestigial words should be in the appendix. That's a good one. Greetings, juxtaposart. Right, audit them. Greetings to you. I hear probative versus prejudicial in many court cases related to evidence. Yes. As we've been going over here, judicial notice is going to be not necessarily litigated in there. It's going to be accepted as fact once it's been noticed and there's been no opposition. And Oakland, greetings to less TV. We all need more or less. We all need less TV. All right. So yeah, I guess this to think between probative and prejudicial, this is true as opposed to being prejudged as true, I guess. Interesting. I'll have to look deeper into that one there, but that's I haven't really heard it too much, so it'd be interesting to see where it applies. Section 156, burdens and presumptions. Burden of proof and presumption embody distinct legal concepts. So now we're getting really down into the differences here. They are related in that a presumption may shift the burden of production as to a particular fact from one party to another, and may aid the party with the ultimate burden of persuasion to satisfy that burden. As a rule, a presumption does not shift the burden of persuasion. Let's read this one again, because this was pretty solid here. Burden of proof and presumption embody distinct legal concepts. See, now they're related, but they embody distinct legal concepts. They're related in that a presumption may shift the burden of production as to a particular fact from one party to another. Wow. Burden of presumption may shift the burden of production as to a particular fact from one party to another. Wow. And may aid the party with the ultimate burden of persuasion to satisfy that burden. Wow, so the burden of presumption can also aid the party. It could shift the burden, or it could aid the party with the ultimate burden of persuasion to satisfy, perhaps meaning that it would cause the other party to produce, which would aid ultimately the ultimate burden of persuasion to the first party that made the presumption. As a rule, a presumption does not shift the burden of persuasion. So as a rule, the presumption does not shift. Whew. Okay, I'm glad to know that AmJur will break this down and make this repeated in more detail and see how it applies. So we'll get more of a thought into action perspective as we continue. So we have some footnotes here, law reviews here, Hoffman and Schroeder, Burdens of Proof. So another great book, I guess, 1986. Sure available from West Group here. All right, we're on to section 157. This was the one we referred to earlier. Degree of proof. Preponderance of evidence and clear and convincing evidence tests. Now, I've heard that one a lot. Preponderance of evidence and clear and convincing evidence tests. Generally, the party with the burden of persuasion must establish the elements of its case by a preponderance of the evidence. That generally occurs when the fact finder is satisfied that the fact is more likely true than not true. Jury instructions defining preponderance of evidence usually include language directing the jury to find against the party with the burden if it is unable to decide whether a preponderance has been shown. Wow. So jury instructions defining preponderance of evidence usually include language directing the jury to find against the party with the burden if it is unable to decide whether a preponderance has been shown. So the benefit of the doubt, right, is against the party with the burden. So if you have the burden, you don't get the benefit of the doubt. Occasionally constitutional or policy considerations. Wow, they just throw that one right out there. Occasionally constitutional or policy considerations impose a greater burden of persuasion. In such instances, the party may be required to prove its case by clear and convincing evidence. Clear and convincing evidence is defined in a variety of ways. For example, to establish a fact or an element by clear and convincing evidence, the party must persuade the jury that the proposition is highly probable, or must produce in the mind of the fact finder a firm believer or conviction that the allegations in question are true. So, here we get the degree of proof. We're breaking down here preponderance of evidence and clear and convincing. So preponderance of evidence is that it's more likely true than not true. And if they can't decide, then it's against the party with the burden. Okay, so occasionally the constitutional impose a greater burden of persuasion, right? In this case here, clear and convincing evidence is defined in a variety of ways, right? Instead of just a preponderance of evidence, the party will be required to prove its case by clear and convincing evidence. And it can be defined in a variety of ways. To establish a fact or element by clear and convincing evidence must persuade the jury that the proposition is highly probable. So it's not just more likely than not. It has to be highly probable. What degree is highly? It would depend on the instance. Or must produce in the mind, talk about subjectivity, of the fact finder a firm belief or conviction that the allegations in question are true. So do you see how we're getting to the limits of where the instructions of the jury impose limitations on the persuasion aspect of this? We're starting to see more about why it's not just persuasion by other ways of coercion or personality or other ad hominem ways. It's persuasion with certain degrees of proof. And that is the general aim, to ascertain truth and ensure a fair process for all parties. So let's continue down here. But before we do that, onto the supplement here, let's check in with the chat. And this needs to be refreshed, obviously, here. Oh, gosh, yes. All right. Bill Thomas says a trademark must also be defended against infringement or it becomes lost. And we saw there's statutory authority that says, or a case authority that says, it would be considered abandoned after 2 years of non-use and you had no evidence of intent of future use. So just the intent of future use would be enough to protect it from an abandonment allegation, it seems. All right, let's continue here with the supplement for section 157. Case authorities. While the difficulty of ascertaining where the truth lies may make it appropriate to place the burden of proof on the proponent of an issue, such difficulty does not justify the additional onus of an especially high standard of proof. So if there's a high standard of proof, wow. So it may make it appropriate to place the burden of proof on the proponent of an issue. while the difficulty of ascertaining where the truth lies may make it appropriate to place the burden of proof on the proponent of an issue, such difficulty does not justify the additional onus of an especially high standard of proof. Okay, so if there's a high standard of proof and there's an additional burden on the proponent, that difficulty does not justify an additional onus of an especially high standard of proof. It's just the standard. Wisconsin cases have long applied middle burden of proof. Oh gosh, middle burden of proof. Evidence that is clear, satisfactory, and convincing in civil actions involving such matters as punitive damages, conduct that could be prosecuted as crime, and allegations of fraud and undue influence, because these matters are more serious than factual issues in ordinary cases and fall within certain classes of acts for which the stigma attaches, and therefore greater degree of certitude is required. Middle burden of proof. Evidence as clear, satisfactory, and convincing in civil actions involving such matters as punitive damages, conduct that could be prosecuted as a crime, and allegations of fraud and undue influence, because these matters are more serious than factual issues in ordinary civil case and fall within certain classes of acts for which stigma attaches, and therefore greater degree of certitude is required. Wow, that's incredible. Wisconsin have long applied the middle burden of proof. Interesting concept there. And this is from our supplement from, see, that case is 1995. Carlson and Erickson Builders versus Lampart Yards. Here, the party asserting negligence must prove negligence by a preponderance of the evidence. And that's in the Southern District of Florida. Let's see, you don't have the year there. That's just a footnote. Okay. Plaintiff must show by a preponderance of evidence that the defendant's negligent act or omission violated a duty owed by the plaintiff, and that there is a reasonable connection between the act or omission and plaintiff's injury. As to the elements of actionable negligence, generally see, negligence. All right, we have some forms, instruction of the jury, definitions regarding preponderance of evidence. Those will be in the practice and pleading editions here. Here we go. Clear and convincing evidence is evidence by a credible witness whose memory of the facts about which he testified is distinct. Not like some of them will go up there and give bad information directly to the judge, right? Whose narration of the details is exact and in due order, and whose testimony is so direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitance of the truth of the facts related. To make out a case of common law deceit, plaintiff's evidence must be clear and convincing, that is, free from confusion, fully intelligible, distinct, and established to the jury that the defendant intended to deceive the plaintiff or did so with a reckless disregard for the truth. That was from Riley Hill, General Contractor Incorporated versus Tandy Corporation. Wasn't that like Radio Shack? Is that Texas, Oregon? No. Okay. So, making out a case of common law deceit. Now, this is an interesting one here, and this would be an interesting case to check up on, which we might do in a future episode. All right, now we're on to allocation. Second part of this chapter. Before we do that, let's jump over to the chat. During voir dire for my last jury duty, the judge asked me if I was okay with the preponderance standard. I said not if punitive damages were at stake. I was shocked when he said I was correct. Geez, they ask those kind of questions? Wow, if I was okay with the preponderance standard. Yeah, you don't want you want a clear and convincing evidence when there's punitive damages, right? Yep, clear and convincing is required. California at least. Yeah, the Trash 80. Yeah, and it was a Texas company, but the case was in Oregon. I guess they're operating in many states. I miss Radio Shack. All right. On to section 158 generally. And this is allocation now. Typically, the plaintiff has the burden of pleading and proving every essential fact and element of his cause of action. The plaintiff is obliged to prove only the facts that are necessary elements of its claim. It need not prove facts it unnecessarily pleaded that are not elements of its cause of action. Courts often remark that the burdens of production and persuasion on an issue rest with the party that pleads the affirmative on the issue. This is another way of saying that a party has the burden of proving the legal elements of its case. When the law underlying a lawsuit is legislative in origin, so legislative pertaining generally, not necessarily specifically to the conditions or situation or the parties specifically, I believe, is what this is referring to. When the law underlying a lawsuit is legislative in origin, courts generally attempt to resolve burden allocation requests by deferring, when possible, to legislative intent. However, legislators often do not adequately address burden issues. True, when this occurs, the court could, for example, make the issue part of the underlying cause of action which plaintiff must plead and prove, or could give the defendant the burden of pleading but impose upon the plaintiff the burdens of production and persuasion. The law underlying a lawsuit is legislative in origin. Interesting. As opposed to constitutional, I would assume here, or statutory, or otherwise. I'm not too sure here, but this would be interesting here. That's footnote 99. Stedman versus SEC. Never mind. Okie doke. As a rule, a party is under no obligation to anticipate and negate, in its own case, in chief, any facts or theories that may be raised by another party. Nor is the party with the burden of persuasion obligated to offer evidence on matters that are not made issues in the case by the pleadings. Moreover, a party may be relieved of its burden of production if the necessary proof is introduced by his adversary, and if such proof is sufficiently convincing and uncontroverted, the burden of persuasion as well. Wow. So you're relieved of the burden of production if the other party brings it, and if such proof is sufficiently convincing and uncontroverted, the burden of persuasion is also relieved. So your other party can help you by producing evidence, lowering that threshold, or relieving that burden, I should say. It is often said that the burdens of production and persuasion lie upon the party who, absent meeting his burden, is not entitled to relief, or upon the party that would be unsuccessful, if no evidence were introduced on either side. Wow, that's an interesting way to look at it logically. It is often said that the burdens of production and persuasion lie upon the party who, absent meeting his burden, is not entitled to relief. So if the burdens lie upon the party, so without that burden being met, is not entitled to relief. So the burden is used. The plaintiff, let's see, the defendant would be the one not entitled to relief. So the burdens of production and persuasion lie upon the party who, absent meeting his burden, is not entitled to relief. Or upon the party that would be unsuccessful if no evidence were introduced on either side. So again, that would be, I guess, typically the plaintiff. Similarly, courts often observe that the burdens of production and persuasion generally fall upon the party seeking a change in the status quo, or upon the party that asserts the claim. Okay, that makes a little more sense there. So the courts often observe that the burdens of production and persuasion generally fall upon the party seeking a change in the status quo, or upon the party that asserts the claim. Annotation here, pleading and burden of proof in contempt proceedings as to ability to comply with order for payment of alimony or child support. Geez. Burden of proof in actions under general declaratory judgment acts. And here are some forms. Instructions to jury, party on to whom burden rests. In a copyright infringement action, defendant's assertion of independent creation did not impose upon it the burden of persuasion on that issue, as plaintiff at all times has the burden of proving that the defendant copied plaintiff's designs. Defendant's assertion of independent creation did not impose upon it the burden of persuasion on that issue. Oh, okay. Interesting. Let's see here. When plaintiff avers generally, so to aver to make a statement of truth or fact, when a plaintiff avers generally that it has performed all conditions precedent to a contract, defendant has the burden of specifying in its pleadings the conditions its claims were not performed. Let's see here. Failure of plaintiff to make general averment regarding conditions. So the failure of plaintiff to make general averment regarding conditions precedent requires plaintiff to prove performance of each condition ab initio, and releases defendant of burden of pleading the conditions it claims were not performed. Nice for contract stuff here, huh? Writ of error. Well, it's a different one here. Where is it? But the failure of plaintiff to make general averment regarding conditions precedent, because remember it's about what was the conditions precedent to a contract. So this would be an interesting case to look at. I wonder what that would be down about. Dairyland County. And this one here is Trevino versus Allstate Insurance. Okay. All right, yeah. Okay, insurance. All right, now we're on to section 159, negative assertions. But before we do that, let's jump back over to the chat. Many negatives strung together and some of the burdens in production language. This hurts my brain. Yes. Yeah. Avertment is to avert. It comes from the root truth, veritas. But we could jump into Black's Law to make sure we have a clear legal definition of the word. So let's do that. And jump over to Black's. And let's see what we got here. Vermin's going to be somewhere here in the A's. Oh, wow, okay. Might be somewhat close. It's going to be a minute here for it to catch up. Here we go. Yes, here we have all these great affidavits go forever. Affidavit service from 18th century. An affidavit certifying the service of a notice, summons, writ, or process. Nice. Almost there. Bear with me here, guys. Probably need like the Jeopardy music or something going on while I do this. Has it been 2 years yet? Arm's length. Almost there. Jeez. You know what? We're going to have to do a bigger leap. Post-audit. The audit of funds spent on a completed capital project, with the purpose of being to assess the efficiency with which the funds were spent and to compare expected cash flow estimates with actual cash flows. Post-audit. Not to mention the periodic audits, an audit conducted at regular intervals to assess a company's current condition. And of course, transaction, the transactional audit, an audit performed for due diligence purposes to determine whether there are potentially significant problems with a transaction. Transactional audits are often conducted in real property transactions to identify any environmental problems. In that context, the audit is sometimes called a site assessment. And the audit letter is a written request for an attorney, banker, or someone else to give financial auditors information about a person or entity being audited, including information about pending or threatened litigation. The receipt of an audit letter usually sends the response, called the audit letter response, directly to the financial auditor. So this is financial audit stuff. And self-authentication from 1939, authentication without intrinsic evidence of truth or genuineness. In federal courts, as we read about in the earlier editions here of Judicial Notice, certain writings such as notarized documents and certified copies of public records may be admitted into evidence by self-authentication. All right, let's get to averment. Just passed it. Okay, so we get aver from the 15th century, to assert positively, especially in a pleading, to allege. And averment. Here we go. Averment is also from the 15th century, a positive declaration or affirmation of fact, especially in an assertion or allegation in a pleading. The plaintiff's averment that the defendant ran a red light. Here's another one. Asseverate. Then we have the material averment from 18th century. An averment that alleges something in needless detail. A statement that goes far beyond what is an issue. Oh, I like that one. This type of averment may be ordered struck from the pleading. Then there's the negative averment from the 18th century. An averment that is negative in form but affirmative in substance, and that must be proved by the alleging party. An example is the statement, "She was not old enough to enter into the contract," which is more than just a simple denial. Then we have averment of notice, a statement in a pleading that someone else has been properly notified about some fact, especially in special actions of assumpsit. See notice. All right. I think we've gone far enough down the averment trail. Yep, that's it. See notice. Okay. I hope this, I just realized this thing was over there. Yeah, you're welcome for the deep dive. I hope everyone could see it there. I didn't realize the screen was covered there during that. So let's get back to this. But we heard it. So now we have a deep dive into averment. And again, I mean, it's a lot more honorable when you're in a situation in court. If you're making pleadings or something like that, to make averments rather than arguments, because the argument should have been done before offering and accepting a contract or any kind of agreement, and after that fact it would be wouldn't be within the most honorable position to be arguing it after the fact. A conditional acceptance or something of that matter might be better. However, if there's factual insufficiencies or inadequacies within whatever the claims are, then that's where the averments come in. So let's continue. Whoever asserts a claim or defense that is negative in form or depends upon a negative proposition has the burden of establishing the truth of the assertion. Thus, for example, the party who asserts invalidity of a statute as the basis of his or her claim for defense has the burden of establishing it. A party seeking to take advantage of an exception to a contract is charged with the burden of proving facts necessary to come within the exception. See, it's not an argument here, it's an exception. And the invalidity of an ordinance or resolution must be established by the party asserting it. Similarly, the burden rests upon the party who assails the validity of a marriage, which is prima facie regular, or a foreign divorce decree, which is regular on its face. There is some authority that within a foreign divorce, this is a good one. There is some authority that when an exception or exemption is contained within the enacting clause of a statute, the party relying on the statute must prove that his case does not come within the exception, but otherwise the burden of proof is on the opposite party. Where the facts, whether the case at hand fall within a statutory exception, are particularly within the knowledge of one of the parties, it is the burden of that party to prove such facts. So the exceptions are proved by the party that has knowledge, particularly within the knowledge of one of the parties. If they both don't have knowledge, then one of the parties that has the knowledge has the burden to prove that fact. Right. It's the application of this rule with regard to criminal statute, C 176. And we're on to section 160, the defenses and counterclaims. Let me jump over here and make sure the chat's refreshed. Okay, now I can read this. Yeah, the audit definitions were a great bonus, and they help us get a clear understanding of where the facts are also applied. Some of these same rules also apply in audits. The defendant has the burden of proof with regard to counterclaims and most affirmative defenses. See, so if there's affirmative defense, the defendant then has burden of proof. No longer on that plaintiff there. Defenses can be divided into three general categories. Here's our three categories of defenses: denial, burden-divided defenses, and affirmative defenses. All right, let's break these down. A denial is a defense in which the defendant simply denies the truth of plaintiff's allegations. It does not oblige defendant to prove anything affirmatively. The burden of persuasion as to each element of the plaintiff's case continues to rest on the plaintiff throughout trial. Footnote 20, Austin versus Memphis. Part is on other grounds. Here too, Lexis later remanded. 1990. Interesting. Wow. Occasionally, the law divides the burdens in connection with certain defenses and assigns the burdens of pleading and production to the defendant, while imposing upon the plaintiff the burden of persuasion. Wow. Footnote 21. Keeler Brass Company versus Continental Brass. Defense of independent creation and copyright infringement. Defendant must satisfy the burden of production when raising the statute of limitations as a defense. Oh, wow. Interesting there. All right, so we get the defenses and counterclaims. Mostly, there's a denial, a burden divided defenses, and affirmative defense. Let's see here. The burden of persuasion as each of the elements plays. Okay, so this is the divided one. Okay, that's the divided one there. So the burden is divided in connection with certain offenses and assigns the burdens of pleading and production to defendant, and the burden of persuasion to the plaintiff. So to show that those facts are relevant are required by the plaintiff, but the facts are produced by the defendant. Interesting there. All right, so now we're on to section 161, comparative availability of proof. And let's jump over here to the chat. Make sure we're all good and clear on that. Indeed. Let's proceed. Where information necessary to prove an issue is peculiarly or exclusively within the possession of one party, courts sometimes reason that convenience and fairness justify placing the burdens of pleading and proving those facts upon that party. A specialized application of assigning burdens in accordance with a peculiar knowledge may be seen in cases involving concurrent negligence, but with but a single unidentified cause. That's a difficult one there. A specialized application of assigning burdens in accord with peculiar knowledge may be seen in cases involving concurrent negligence, but with a single undefined cause. So there's peculiar knowledge for concurrent negligence, 23. Summers versus Tice, California, overruled on other grounds by Sindel and Abbott Laboratories. All right, let's see here. When two or more persons, by their acts, are possibly the sole cause of harm, or when two or more acts of the same person are possibly the sole cause, and the plaintiff has introduced evidence that one of the two persons or one of the same person's two acts is culpable, then the defendant has the burden of proving that the other person or his other act was the sole cause of harm. The defendant says that the other person, wow, turns you into a snitch. All right. But I digress. Let's continue. All right, where were we on that one? 23. Some courts have taken a similar approach in products liability litigation involving asbestos, Agent Orange, and other toxic substances, holding an industry as a whole liable for injuries sustained by a class of plaintiffs, and apportioning damages according to each defendant's share of the market, unless a given defendant can show that it could not have made the product which caused a particular plaintiff's injury. Oh gosh. Where proof is offered that one of several parties made an admission, but the identity of which one cannot be definitely established because the plaintiff was unable to specify which defendant was the declarant, the burden of proof shifted to each defendant to deny having made the statement. Wow. Footnote 25. Nothing special on that, just the authority there. All right. Courts have sometimes eased the burden on a party that faces unusual difficulties in obtaining evidence, even if the adversary does not necessarily have greater access to such evidence, such as a plaintiff who is not available to testify or who, because of amnesia, convenience, cannot remember the events in question and is therefore handicapped in rebutting an allegation of contributory negligence. So, here we have a recommendation based on that. Here's one for the clipboards. To safeguard against phony claims of amnesia, a jury should be instructed that before the lesser burden of persuasion is applied, because of the danger of shamming, they must be satisfied that the evidence of amnesia is clear and convincing, supported by the objective nature and extent of any other physical injury sustained, and that the amnesia was clearly a result of the accident. A party cannot avoid the normal allocation of burdens merely because needed information is possessed by a non-party who refuses to cooperate and is privileged from testifying. So you can't avoid it because a non-party refuses to cooperate. Interesting there, and that's footnote 29. Bank of Crete. Oh, geez. All right. So this is where we're going over here. These sections here, we're to go over allocation. As you can see here, what we mean by allocation is where are each of these different burdens allocated to? Who gets it assigned to producing, or satisfying, I should say, that particular burden? And that takes us on to the third chapter. The third chapter, which is constitutional, or the third section of this chapter, which is, or the third part of this chapter, constitutional considerations. Section 162, due process. The burden of proof in civil cases is normally not an issue of federal constitutional moment. Occasionally, however, constitutional considerations do affect who may be required to prove what and the degree of persuasion the burdened party is required to satisfy. The burden of proof the government or state must satisfy in a proceeding against an individual is an important component of due process for two reasons. First, the standard of proof reflects the importance of a particular adjudication. Second, the more stringent burden of proof a party must bear, the more that party bears the risk of an erroneous decision. Wow. So this is pretty heavy here as far as due process, right? And that the fact that government or state must satisfy in a proceeding against an individual is an important component. So we need standard of proof reflecting the importance of a particular adjudication. The standard of proof reflects the importance. So second, the more stringent burden of proof a party must bear, the more a party bears the risk of an erroneous decision. So the more the quantity, let's see here. See, the more stringent the burden of proof. So this is going to be the most details, right? The largest the risk of erroneous decision. So this gets into the level of complexity, this more stringent the burden of proof, how much details. And it's hard to keep the attention of a jury. Fortunately, we have a better audience here that we're able to keep this attention here for over an hour now, it seems. So salute to you all. The function of a standard of proof, as that concept is embodied in the Due Process Clause and in the realm of fact-finding, is to instruct the fact finder concerning the degree of confidence our society thinks he should have in the correctness of factual conclusions for a particular type of adjudication. I wonder how much this has changed over the last 20 years or so. Let's see here. Footnote 33. Addington versus Texas, criticized on other grounds by Patterson versus New York. Okay. All right, so once again, see, function of a standard of proof, as that concept is embodied in the due process clause in the realm of fact-finding, instructing the fact finder concerning that degree of confidence, how much they're willing to believe. And again, American jurisprudence always brings into the aspect of the conditions of the society, right? The degree of confidence our society. So this is a temporal function here because it's going to be our present day society thinks he should have in the correctness of factual conclusions for a particular type of adjudication. So what would our society expect someone of someone who has some knowledge, intellect, and wisdom, right, have in the correctness of factual conclusions for a particular type of adjudication? Due process requires only a mere preponderance of the evidence to justify the state depriving an individual of a financial right. Wow. A mere preponderance when you're talking about the state depriving an individual of a financial right, when the individual interests at stake in a state proceeding are both particularly important and more substantial than mere loss of money. However, the state must justify its action by clear and convincing evidence rather than by the traditional civil standard of mere preponderance. Wow. So to deprive, so I'm reading this right now here, the state depriving an individual of money. Oh, okay, so that's pretty bad. When an individual interests are at stake in a state proceeding are both particularly important and more substantial than mere loss of money. However, the state must justify its action by clear and convincing evidence. Okay. The clear and convincing evidence standard has been required in deportation proceedings, in denaturalization proceedings, in civil commitment proceedings, and in proceedings to finally and irrevocably terminate parents' rights to custody of their children. Wow, clear and convincing, I guess so. A state may permissibly impose the clear and convincing standard to protect a state interest, preservation of human life, in litigation brought on behalf of an individual against the state. That's interesting there. And we're down to free exercise, section 163 for our constitutional considerations here. Burdens of proof have a role in reconciling conflicts between an individual's right to the free exercise of religious beliefs and practices and legitimate government interests. To validate an action that substantially burdens a religious practice, the government must establish that its action was justified by a compelling state interest. But this rule applies only where a government agency engages in individualized assessments of the reasons for the individual's conduct. Absent such circumstances, the agency need not show a compelling state interest. It need merely show that it was enforcing a general, applicable, religion-neutral law. Well, we've seen how this played out. So let's see. Footnote 43, Employment Division, Department of Human Resources versus Smith. Okay, let's see this one here. It's on remand in Indiana, invalidating state unemployment compensation rules that conditioned the availability of benefits upon an applicant's willingness to work under conditions forbidden by his religion. The application is a contract. Don't let them tell you otherwise, because we were just talking about contractual obligations and such here. Religion-neutral law, contract law. They're slick. All right. And we're on to procedural issues. So, on to part 4, procedural issues, section 164, satisfying proponent's burden of production. Opponent's motion for a directed verdict. Let's see here. Bill Thomas says, a strong burden of proof means more will escape justice, but we will accept that to avoid false convictions. And as it's stated there, it's already been, I guess you could say, presumed to some extent that there's a higher degree of error when there's a higher burden of proof. So it takes more diligence and vigilance, I guess, when you're vigilance, diligence and vigilance, when you're dealing with the more difficult of cases. It is better 10 guilty persons escape than 1 innocent suffer. Yep, Blackstone's ratio, indeed, and that goes to our common law. So thank you for that anecdote there. Let's proceed here. So we're on to satisfying the burden of production. The opponent's motion for directed verdict. The opponent's motion. The proponent's burden of production means that he must produce sufficient evidence so that a rational jury or other fact finder could find that each of the elements of his claim has been proven by a preponderance of evidence. The adequacy of the proponent's evidence is tested when, after he rests, the opponent moves for a directed verdict. If the proponent has failed to satisfy the burden of production, the opponent's motion will be granted. Wow, that's where they pull it from the jury. In ruling on a motion for a directed verdict, a judge must also apply the rule that witness credibility is for the jury, not the court, to decide. A party cannot, however, sustain its burden of production by calling adverse or hostile witnesses, eliciting testimony that negates its cause of action, and then arguing that the jury could find for that party simply by disbelieving these witnesses. Wow. Of course, we've seen that kind of play out, huh? 47. Let's see what case that was. We'll come back to the rest of the footnotes. Pennsylvania. All right, let's look at the rest of these footnotes here. We already went through section 157. We got our fine definitions of preponderance of evidence. The party with the burden of production must introduce sufficient proof to submit the case to the fact finder. And here we got motions for directed verdicts are generally discussed in 75 AmJur trial. That's a good one we should go over sometime. Some of these AmJurs get real intense. Well over 100 volumes here, so we get to touch on about every topic. Now in section 165, the drawing inferences. In deciding a motion for directed verdict, the judge must give the non-movement the benefit of all reasonable inferences that may be drawn from all of the evidence that has been admitted. All reasonable inferences to the non-movement, the benefit of all reasonable inferences that may be drawn. So the moving party bringing the evidence, the non-moving party essentially here gets the benefit of the doubt that any reasonable inferences that he draws from that evidence produced by the other party that's been admitted, he gets the benefit of those inferences. Although a court must allow the jury to draw reasonable inferences, a party cannot satisfy its burden of production with evidence that supports only an abstract or theoretical probability, or evidence that would require the jury to engage in speculation or conjecture. When direct evidence as to an element of a claim or defense is lacking, and the circumstantial evidence arguably supports conflicting inferences, one favoring plaintiff, the other favoring the defendant, courts occasionally hold that the party who does not have the burden of persuasion is entitled to a direct verdict. because to submit to the question to the jury is to permit the jury to indulge in speculation and conjecture. That's nice. Circumstantial, see, is a claim or defense is lacking. And just the circumstantial, not the testamentary evidence, arguably supports conflicting inferences, right? Courts occasionally hold that the party that does not have the burden of persuasion is entitled to a directed verdict. That's interesting, though, because they don't want the conjecture of a jury or speculation. Another view holds that it is the jury, not the court, which weighs the contradictory evidence and inferences, judges the credibility of witnesses, receives expert instructions, and draws the ultimate conclusion as to the facts. Wow. See, that's footnote 50 and 51. The party fails to meet its burden of production when the evidence equally supports the party's opposing theories. All right, let's look at the supplement really quick here. We have some case authorities in determining an accused's guilt under a criminal statute. A jury may find the requisite knowledge of the law on the accused part by drawing reasonable inferences from the evidence of the accused's conduct. In case involving accident at railroad grade crossing, yikes. These are not pretty. Trial court did not abuse its discretion in limiting testimony as to prior accident where main issue was whether vegetation, line of trees, obstructed view at crossing, and, by way of countering possible inference that prior accident had also involved vegetation, railroads sought to show that prior accident did not involve vegetation. Whether such inference was created at all was questionable, and in any event, trial court simply foreclosed what could have been substantial detour into collateral issue. A prosecution for robbery of 3 fast food restaurants in which defendant offered alibi. Adverse inference from defendant's failure to call his mother as witness was permissible, where mother had been present when defendant apologized to owner of restaurants. Oh my God. I thought your mother couldn't be your witness for an alibi in court. 1994. Now that was funny. Here we got Gunther versus Armstrong Rubber, and to satisfy the burden of producing evidence that the defendant manufactured the particular tire that caused plaintiff's injury, more is required than showing that a defendant manufactured 70 to 80% of the tires that were sold at the store where plaintiff had purchased the tire in question. Wow. See, which court charged the jury the facts which are consistent with either of 2 opposing theories proves nothing. All right, which court charged the jury the facts which are consistent either of 2 opposing theories proves nothing. Okay. Party fails to meet its burden of production when the evidence equally supports the party's opposing theories. That's funny. All right, we're on to 166, section on shifting burdens. And before we do that, let's jump over here to the chat. Must be a directed verdict happen before jury deliberation, or can it happen later? No. Well, I don't know about that, but for the purpose of the directed verdict is to keep the jury from deliberating on it at all, that there's nothing for them to deliberate on. It would only be speculation at that and conjecture. Therefore, since the facts give no reasonable verdict other than the one being directed, then that would be that motion for a directed verdict. You'll see this a lot. That's a typical Esquire move. If you've gone, you got to think about it this way too. If you've gone through the trouble to initiate a jury trial, and now you're going to do a directed verdict, I mean, there's something wrong in that whole approach, I think, to one of the 2 parties. but that's just what my opinion is. That a party has satisfied its burden of production generally does not affect, change, or shift the burden of persuasion on the elements of the cause of action, defense, or counterclaim, as the case may be. The party who begins with the burden of persuasion on any issue retains that burden on the issue throughout the trial. If the opponent's motion for a directed verdict is denied, he faces what is sometimes called the risk of non-production. If he produces no evidence, he runs the risk that the jury will find the proponent has met his burden of persuasion. This does not, however, shift the burden of production. The proponent continues to have the burden of establishing each element of his cause of action by a preponderance of the evidence, and the jury must still decide whether he has satisfied that burden. So if the opponent's motion for a directed verdict is denied, he faces what is sometimes called the risk of non-production. If he produces no evidence, he runs a risk that the jury will find the proponent has met his burden of persuasion. This does not, however, shift the burden of production, since the proponent continues to have the burden of establishing each element of his cause of action by a preponderance of the evidence. The jury must still decide whether he has satisfied that burden. Wow. So here's our annotation, pleading and burden, contempt proceedings, as ability to comply with order for payment of, oh geez. See, is proceedings, same thing there. All right, we're on to, I think, the last section here for this part, substance or procedure in diversity cases. Oh, Lord. The burden of persuasion is generally considered an issue of substantive law rather than procedure, in the sense that if a judge misinstructs the jury as to who has the burden or what that burden is, this is likely to be a reversible error. In federal courts in diversity cases, the prevailing view appears to be that the burden of production is a procedural question to which federal law applies. But the allocation of the burden of proof, remember who is allocated to which aspects of these burdens, as to the elements of a claim or defense is considered substantive. So whenever a federal court must apply substantive state law, it must look to state law to determine which party bears which burden on which issues. Wow. So this is where the state laws would guide the federal court. State laws as to the sufficiency of evidence governs, and the burden of persuasion is a substantive issue to which state law applies. Heavy duty. So that's some high level stuff we're learning here, and that takes us on to section B, which we will get on to next time, and that is in criminal cases. And beyond reasonable doubt standard is what we'll be starting with. So this looks pretty enticing, but we definitely have taken on quite a bit tonight. So I appreciate everyone that showed up for showing up. Let's check back here at the chat and make sure we're all up to date here. Yeah, thanks for sticking around the whole time, Bill Thomas. I'm sure you picked up a lot on this because I noticed you're putting in the best questions here into the chat. So I think that we're going to all have a much deeper understanding of the burdens of production and persuasion, which are parts of that burden of proof. So by seeing how these are all subdivided and getting a fuller comprehension and really the interaction of the way the whole law of evidence functions within the courts and the various courts really gives insight into its intent, which is to ascertain the truth and to provide a fair process for all parties. And with that, I think that's one of the ideals of our style of American jurisprudence and common law here on America. So it's pretty much our duty to reciprocate that generosity and be sure to make sure that this tradition, in whatever form we can maintain it, will be preserved and conserved for future posterity. And with that, I would like to thank you all for attending, and I hope to see you all on the next one. Peace out.